What happened at the trial following Lincoln's assassination? What was the fate of the conspirators? And was the trial legal? Let's find out in today's episode of the History Chronicles. For the first time in American history, the President of the United States had been murdered. The assassination of Abraham Lincoln by the Lincoln conspirators was met with universal outrage. Robert E. Lee, leader of the Army of Northern Virginia, expressed sadness at his loss, and General Ulysses S. Grant said Lincoln was, quote, "incontestably the greatest man I ever knew." Following the assassination, Secretary of War Edwin Stanton assumed an almost dictatorial level of power in the ensuing investigation, arresting suspects and organizing the trial and punishment of those believed to be responsible for the plot. As the investigation continued, Stanton was given grounds to believe that there was an even greater conspiracy when Secretary of State Seward was attacked in his bed. As the conspirators were arrested, Stanton gave specific orders regarding the prisoners. They were to be kept in ball and chains, with canvas hoods placed over their heads, and were to be kept aboard the USS Montauk and USS Saugus. Dr. Samuel and Mary Surratt would be held at the old Capitol prison instead of the ships. Lewis Powell attempted to commit suicide on the 27th of April 1865 by banging his head against his cell wall, resulting in the addition of padding to the hoods to prevent future suicide attempts. In total, 7 men and 1 woman would be brought to trial for their role in the conspiracy to assassinate the top 3 executive branch members. On the 1st of May 1865, Vice President Johnson ordered the trial be conducted by a military tribunal. On this order, Major General David Hunter was assigned as the senior officer who would oversee the trial. Joining him would be Major General Lewis Wallace, Brevet Major General August Kurtz, Brigadier General Albion Howe, Robert Foster, Thomas Harris, Brevet Brigadier General Cyrus Comstock, Brevet Colonel Horace Porter, and Lieutenant Colonel David Clendenin. Of those on the original commission, General Comstock and Colonel Porter disagreed with the military receiving jurisdiction over the trial, and were both excused and replaced with Brevet Brigadier General James Erin and Brevet Colonel Charles Tompkins. The decision to convene a military tribunal was hotly contested both before and after the trial, as even members of the commission had brought up the legality issue. Secretary of War Stanton recommended the conspirators be tried by military tribunal, as he believed a civil court was too risky for the conspirators to be deemed not guilty, and if convicted, could result in a dragged-out appeals process. In fact, Attorney General James Speed defended Stanton's opinion and upheld it in his official view. As part of this view, since Washington fell under Lincoln's martial law declaration, which was established on the 15th of September 1863, the writ of habeas corpus had been suspended. As a result, Stanton argued that since habeas corpus had been suspended, the military would have oversight over the trial. Opponents of this argument would disagree, stating that only if the civil courts were not working should a military trial be convened. Yet in 1862, Lincoln declared in a proclamation, "All rebels and insurgents, their aiders and abettors, guilty of any disloyal practice against the authority of the United States shall be subject to martial law and liable to trial and punishment by court-martials or military commissions." Reverdy Johnson, the attorney for Mary Surratt, argued that the Constitution gave the President his powers and that the military had no jurisdiction to try civilians. Reverdy Johnson would further argue that since none of the defendants were residents of rebellious states, they would not fall under the category of rebels. A counterpoint to Johnson's argument is the fact that the conspirators did act as aides to the rebel cause. Despite Johnson's objections, other cases during the Civil War against civilians were tried in military court, seemingly setting a precedent. Despite this, the defendants claimed that since they were civilians living in loyal states, they should be tried in civil court with a jury and have the rights enshrined in the Constitution applied to them. The final decision was that the conspirators acted in the aid of the rebellion, while the rebellion was still in effect, and that the crime was committed against a military officer, since Lincoln was the commander-in-chief of the armed forces, in an area subject to martial law, and therefore trial by military commission was appropriate and necessary. The military commission convened on the 9th of May 1865, and by the next day they established the rules of the trial. On the 12th of May, the trial began in the old Arsenal building, with witness testimony, but not without public outcry. Originally, the trial was declared to be a secret, with no public access or reports to the press. After protests, the secrecy was lifted on the 13th of May, and the Washington Daily National Intelligencer and Philadelphia Daily Inquirer posted daily transcripts of the court proceedings. By the end of the trial, 3 versions of the transcripts were published in a book. Judge Advocate General Joseph Holt was assigned as prosecutor of the case, along with John Bingham and Colonel Henry Burnett. As part of their case, the prosecution decided instead of simply proving guilt, they would prove those brought to trial were in league with the highest level of the Confederacy's leadership. As the prosecution brought forward witnesses, individuals such as Richard Montgomery and Charles Dunham, who testified under the name Sanford Conover, backed up the prosecution's claim. Montgomery testified that Jacob Thompson, leader of the Confederate agents in Canada, had said he could at any time have had the tyrant Lincoln and any other of his advisers that he chose put out of the way, that they would not consider it a crime when done for the cause of the Confederacy. Dunham, during his testimony, stated hearing Thompson discussing the plot to assassinate Lincoln along with other Union leaders. Dunham testified the plot had been approved by the leaders in Richmond, along with the Croton Dam plot, which was a plan to poison the water supply for New York City, and the yellow fever plot, in an attempt by the South to spread yellow fever throughout the North. Dunham would eventually lose his credibility during the trial and be perjured as a result, throwing his credibility into question. Following in the line of questionable witnesses was Henry von Steinacker, who described a secret meeting following the Battle of Gettysburg with Confederate generals and Booth, in an effort to put together a plan to free Confederate prisoners of war and spark fires in the northern cities. This plot supposedly also included killing members of the cabinet and the president. The first aspect of the prosecution's case against the 8 defendants was not solely based on the assassination carried out, but also sought to establish a pattern of a combined effort by Confederate leadership to destroy Union ships and cities and introduce diseases into the civilian population while striking fear into the heart of the Union. Not only did they establish probable cause that the Lincoln assassination could have been plotted by Confederate leaders, but the Confederacy had been actively attempting to limit the Union's ability to wage war. As a result, capturing or assassinating Lincoln could indeed limit the Union's ability to wage war, but during the cross-examination, the defense failed to properly dismiss these claims, and instead claimed that these events were unrelated to their defendant's case. As the government continued its prosecution, the case against Herold and Powell grew stronger than the case against Atzerodt, Arnold, and O'Loughlin. The trio admitted to being involved in the plot to kidnap Lincoln, but refused to acknowledge their involvement in the assassination plot. Minchin Lloyd, the tavern keeper at Surrattsville, was the most important witness, as he testified John Surratt had given him 2 carbines, ammunition, and other supplies for Herold and Booth 6 weeks prior to the assassination of Lincoln. On the night of the assassination, Herold retrieved the items with Booth, showing their involvement in the assassination. Other witnesses would also place Herold with Booth, solidifying the case against them. The best witness against Powell was the houseboy to Seward, William Bell, who faced him directly and spoke to him before the attack. Those who were stabbed by Powell were also able to identify him, along with other members of the House staff. Following the testimony against Powell, Marcus Norton testified against Atzerodt and O'Loughlin. Norton stated he had seen Booth with Atzerodt at the National Hotel and overheard a discussion involving a Mr. Johnson, in reference to the Vice President. Norton also testified on the 3rd of March 1865 that Norton had a gentleman mistakenly knock on his door in the National Hotel asking for John Wilkes Booth. The man who knocked at his door was Dr. Mudd. Samuel Arnold's piece of evidence against him was a letter from Booth, addressed to him and acknowledging both his own role along with that of co-conspirator O'Loughlin. Mary Van Tyne often rented rooms to the pair and stated that Booth visited them frequently. The prosecution would lay the foundation to establish Dr. Mudd's Confederate sympathies through the testimony of his former slave, Melvina Washington. Washington testified Dr. Mudd frequently entertained guests and needed to post watches outside his home to alert the party to stop treasonous conversations if danger approached. Mary Sims, another former slave, identified John Surratt as one of the guests during these parties. John Surratt consistently stopped at Dr. Mudd's house and conversed secretly with him. The next witness would be critical to proving Dr. Mudd and Mrs. Surratt's guilt, as Louis Weichmann had been introduced to all the defendants at Mrs. Surratt's boarding house by her son, John. Whenever John was not present, Booth would ask for Mrs. Surratt to deliver messages. Weichmann would be given credit as having the most impact on the case against Mrs. Surratt. The last of the conspirators, Edmund Spangler, had the weakest case out of all the defendants. He struck fellow stagehand Jacob Ritterspur and told him not to rat out Booth. The prosecution would rest their case, giving way to the defence. The defendants were led by an array of attorneys, with some overlap occurring between them. Reverdy Johnson, US Senator and former Attorney General, represented Mrs. Surratt, along with his co-counsels John Clampett and Frederick Aiken. General Thomas Ewing Jr. and his father Orville Browning would represent Dr. Mudd, Spangler, Arnold and O'Loughlin. Dr. Mudd would also be represented by Frederick Stone, who would also defend Harold, while O'Loughlin's counsel would include Walter Cox. William Doster, a former Washington Provost Marshal, would represent Atzerodt and Powell. He would be assigned to defend Powell, as he had not been able to find another lawyer to represent him. To say the defence attorneys were incompetent would be incorrect, as no matter who represented the accused, the evidence against them would be too great for any defence attorney to overcome. For example, Dr. Mudd's pre-trial denial of knowing Booth hurt his defence. Meanwhile, there were many witnesses who saw Powell attack Seward, so Attorney Doster could only hope to get his charges reduced to assault and battery with intent to kill by pointing out none of the men he attacked had died. Atzerodt was nearly impossible to defend, as he confessed to being involved in the plot, although he never attempted to assassinate Vice President Johnson. As a defence, his counsel attempted to depict him as a cowardly individual. One tactic used by the defence was to admit their clients had been conspirators in the plot to kidnap Lincoln, but to deny their involvement in the assassination, in the hopes of a lighter sentence, such as in the case of O'Loughlin. Frederick Stone attempted to picture Harold as weak-willed, mentally deficient and easily influenced. Harold's boss at the drugstore described him as more of a boy than a man. The defence would try to disprove evidence, such as the rope found in theatre employee Spangler's hand. One theatre employee testified it was identical to the type of rope used to shift scenery. The testimony of Louis Carland contradicted the testimony of Jacob Ritterspur, who Spangler had slapped, as he stated. What he actually said was, "You don't know who it is, it may be Booth, or it may be somebody else." It was scandalous for Mrs. Surratt to be brought to trial for a crime such as assassinating a president, as a widowed woman of her standing could surely not have been part of a serious conspiracy. Her legal team attempted to discredit Lloyd's testimony by bringing forward two witnesses stating he was drunk on the night of the assassination. The defence also called into question whether Mrs. Surratt was able to properly identify Powell when he arrived at her home that night, as one of her boarders testified she often needed help threading her needle and struggled to read with a lamp. The prosecution dismantled this defence argument, as the witness also testified during cross-examination that they were not present when Mrs. Surratt failed to identify Powell. On the 29th of June 1865, the Military Commission met in closed session to deliberate along with the prosecution. For those familiar with civil law, this was a drastic change, but in accordance with military law, the prosecutors act as legal advisors to the Commission, while the defence is locked out of the deliberation. The deliberation had no official records available, with only sparse notes from Brigadier General August Courts. On the 30th, the Military Commission returned with a guilty verdict on all 8 defendants. David Harold, George Atzerodt, Lewis Powell and Mrs. Mary Surratt were to be hung from the neck until dead. Michael O'Loughlin, Samuel Arnold and Dr. Samuel Mudd were imprisoned for life with hard labour, while Edmund Spangler was to be imprisoned for 6 years with hard labour. President Andrew Johnson approved the sentencing and ordered the executions to take place on the 7th of July 1865 with oversight from Winfield Scott Hancock. It would be General Hartranft's responsibility to oversee the arrangement of the graves, which would be dug inside the walls of the Washington Arsenal prison near the gallows. All of those sentenced to death had clergymen present during their final hours along with family. Mrs. Surratt's lawyers and even Winfield Scott desperately attempted to have her life spared, but the attempt would be unsuccessful, Roughly 3,000 soldiers were present during the execution, with only a few members of the general public allowed in. At 1:15, Mrs. Surratt emerged dressed in black, supported by Father Walter and Wiggett. She stumbled while she walked. Following behind her was Atzerodt, then Harold, and finally Powell. Powell was the only one who appeared to be composed and boldly stepped forward, while the others had to be pushed onto the planks, which would drop. At 1:26 p.m, the soldiers knocked down the support beams, dropping the condemned. Mrs. Surratt was barely on her spot and fell forward, swinging back and forth, while Powell's neck had not been broken by the fall, and he would suffocate before losing consciousness. After 20 minutes, the bodies were cut down and buried. The final conspirator, John Surratt, was brought to trial in 1867 in a civilian court, and his trial highlighted the seeming injustice those fateful 8 received from the military tribunal 2 years earlier. Lack of evidence and the statute of limitations would cause John Surratt to be found not guilty and released, thus officially ending the trial of the Lincoln conspirators. It could potentially be argued that had the conspirators been brought to court in a civilian trial like John Surratt, many of the conspirators may have been given light prison sentences or never been deemed guilty at all. The trial of the Lincoln conspirators is still greatly debated, although present-day legal scholars tend to believe the trial was unjust and the rights of the accused had been violated. Since the evidence was dubious at best regarding the conspirators being agents of the Confederacy and failing to prove the Confederate government was involved in the plot, the conspirators should have been tried as civilians and not through a military tribunal. You have been watching the History Chronicles. We'd love to know what you think of the Lincoln conspiracy trial. Please let us know below, and if you enjoyed our video, please give us a like and subscribe. It really helps us out. Also, if you'd like to support our work going forward, please visit our Patreon page. And we look forward to seeing you again on the next episode of the History Chronicles.